Okay, good morning. This is the Board of County Commissioners. This is a board work session. It is Wednesday, September 20th, 2023. It is 11:09 a.m. This session is set to go until 11:30 a.m. if we're lucky. This is a hybrid meeting. We're at 3000 Pacific Avenue Southeast, room 110 for public virtual attendance. You may follow along on the Thurston County YouTube channel. I'm Carolina Mejia. I'm the chair of the board. To my right is Vice Chair Ty Menser. To my left is Commissioner Gary Edwards. Also in the boardroom, we have Assistant County Manager Robin Campbell and Assistant County Manager Rob Gelder. We have Jennifer Walker, Director of Public Works, joining us here today, as well as Tim Wilson, and we will be discussing the results of the August 22nd, 2023 public hearing on the proposed rule of rates and charges for Offut Lake Management District number 24 briefing. So passing it to you, Tim, and go ahead and get started.
If I may, I will say we also, at the request of the Commissioner's Office, we also asked our attorney, Deputy Prosecuting Attorney Travis Burns, to be present, and he is participating via virtual. So thank you, Travis.
Thank you very much. Okay, good morning. Thank you. So this is a board requested briefing to discuss public comments received at an August 22nd public hearing. The public hearing was held per statute outlining the formation process for lake management districts. The public hearing on August 22nd was specific to the role of rates and charges for the Offut Lake Management District number 24. So the topics we'd like to discuss today are the Lake Management District formation process, the purpose of the public hearing that was held on August 22nd regarding rates and charges, a summary of the public hearing comments received, and then proposed next steps.
You to handle that?
Sure, thank you.
Yep.
So first, just a recap of the formation process of the Offut LMD. So several steps, as you're becoming well aware. First step is for the board to consider the resolution of intention. There are two public hearings involved in the process. The first public hearing was held November 1st of 2022. That was to hear comments related to the petition of formation itself. That was followed by the board authorizing a vote of the affected property owners. That vote came back affirmative via a weighted vote that is per statute. The board then adopted Ordinance 16291 on July 18th, forming the Offut Lake Management District. And then it became just a continuation of the administrative steps that are called out per statute, that being to hold a public hearing, which the board did on August 22nd for the proposed rule of rates and charges. And then the last step in this process, should the board take action, is to consider a resolution that would amend or adopt the role of assessment. And that is currently on your agenda for next Tuesday. So the purpose of the public hearing, as required by RCW 3661-120, is to hear objections to the special assessment role. It's really an opportunity for ratepayers to review their annual rates and verify they are being charged the correct rate. And as discussed previously, there's multiple classifications with the LMDs. The most common are upland properties and lakefront properties, which are charged a very different rate. This is an opportunity for everybody to put eyes on the rates and the classifications for their property and identify any mistakes with the rule. So we received a very few comments, actually. We received 3 qualifying written votes that were received by the board. And when I say qualifying, I'm referring to statute, statute 3661-120 calls out that in order to be considered, the comments need to be in writing to the board and received prior to the public hearing. So that is a statutory requirement. Additional comments, as you'll recall, were received via public testimony. In review of those comments, both the written comments and the comments that were received in the public hearing, no needed corrections to the role of assessment were identified. So no mistakes were made regarding their classifications.
And that was reflected by the citizens that came in. They didn't bring anything to our attention that there was a deficiency in that regard. Most of it had to do with other things, right?
That's correct.
Okay.
That's correct. So the next slide is just the board options per statute. And again, this is 3661-120. So the county legislative authority may correct, revise, raise, lower, change, or modify the special assessment rule or any part thereof, or set the proposed special assessment rule aside and order a new proposed special assessment rule be prepared. And that really speaks to, making corrections, identified corrections, or if there are multiple corrections, throwing away the rule and coming back with a new one. The county legislative authority shall confirm and approve a special assessment rule by adoption of a resolution. Again, that's on your agenda for next Tuesday at this time. Or if a proposed special assessment, and if a proposed special assessment rule is amended to raise any special assessment appearing thereon or to include omitted property, a new public hearing shall be held, which isn't really relevant in this case. So the next steps, again, staff has submitted an AIS, putting forward a draft resolution for board consideration next Tuesday. And should that be adopted, staff would submit information to the treasurer's office to be included in tax rolls for 2024. And with that, I would be happy to answer any questions the board might have.
Questions, Commissioner Edwards?
So the next step, the RCW basically says shall, unless there's been the discovery of some inconsistencies or issues that maybe don't match that could have been addressed during our hearing, right? So actually, the options of maybe canceling all this out and sending it back, that really isn't applicable in this situation if nothing was brought to our attention that said there was a problem. I don't know, maybe that's a question for council, but I would guess that's where we're at somehow at this point. But I don't know, is that right, Travis?
That's my interpretation. I would leave it to Travis.
Yeah, no, Commissioner, that's correct. The scope of this hearing and the next action are limited to, as Tim put it pretty well, whether or not there are any omissions, errors in the proposed role of assessment that was put out to the public. And so the board's decision coming forward here is whether or not is to consider all those comments that came in and determine if there's any error in terms of the proposed role of assessment. So if a member of the public wanted to dissolve the Lake Management District, that's a different process. That's not where you are here, and that would have to require, among other things, a public petition. But again, as I understand it, where we are in terms of the hearing is very limited in terms of its scope, and your decision is really confined to whether or not there's error in the proposed assessment.
And maybe following up on that, we've got a citizen input here on, was there a discrepancy between what was noted on the website about how this process was going to take place versus the reality of what happened, I guess. I could only refer to that by something about the election of representatives. The first question on the second page here. That's kind of what I.
That comment, as I read it, was a question about what was conveyed out regarding structure of the advisory committee or steering committee, whether, you know, it would be self-appointed or elected. And as you'll recall, going back a year or so, you know, there was some work to establish guidelines for how those committees would be managed that is in continued discussions here.
I
I
think
get-
Commissioner Edwards, were you referring to question number 3? Were you seeking clarification or response on the allowing non-elected state agencies to vote?
No,
No, he's on question one.
No, number one on the second
Okay.
page,
Legal
and
question about.
I just wonder if that becomes an issue if we asked citizens to vote on something and the information we gave them was not what is in the end brought forward as the reality, and so I'm referring to question one on the.
Is this a thing where it's subject to, I'm just guessing, I didn't read the website, so I don't know. But I know we've been jerking around with this issue, I'll put it that way, with respect to admin rules. So did the website say be subject to a series of admin rules and those admin rules are shifting, so that's the issue? Or I don't remember talking about this issue in the context of Offut Lake. I remember talking about it in the context of Long and Lawrence.
Right.
And admin rules that would apply to Pattison and Offut, but I don't know what was communicated specifically to Offut through our website with regard to how this issue would be handled.
Yeah, so first of all, the question that is being raised is separate from the rules and rates and charges and that issue. So, to answer your question about the information that's on the website, it's generic information regarding, and I believe they are speaking to the proposed admin rules that we communicated out, I don't know, 20 months ago or so, that going forward, for Offut and Pattison Lake, the expectation was that they had a elected steering committee that we have since then put a revised version to the board several months ago that took that requirement out of it and said, you know, the advisory committee is, how that is formed is up to the community itself, if they choose to put it.
So they could do an elected, but
They
we're
could
not,
do
we're
an
not
elected,
mandating
they
that
could
they
do
do
an
an
appointed. they
So
could-
the department's position originally, when the administrative rules were developed, is that we had the ability to establish those within the department. And the board gave us direction that any new LMDs that were coming on, we wanted to make sure that they heard directly from the county as to what the process would be. And so staff held not hearings, but meetings with them, and they were virtual meetings and kind of outlined, and we recorded all of that. We established the admin rules. The communication to the existing LMDs, Long Lake and Lake Lawrence, was that some of these are already in existence, but some of the things that aren't, this is like foreshadowing. If you choose to renew, this is what the new administrative rules would be. They provided comment on those, they engaged the board on those, and then we started down this path of what pieces of those administrative rules would stay and what would go. And so that's kind of, I think, what we're talking about. And so what we communicated originally was the administrative rules. There was some back and forth on edits to those, and I think that's what we're talking about now, where there were some changes made.
And to that extent, I mean, what the administrative rules look like will be dependent upon what the board direction is Monday, after we have.
I guess my question is though, if we asked folks to vote and that there would be an elected board, and then we change the rules midstream, does that possibly negate the whole thing? I mean, is there an RCW that addresses that elected board, or is that a staff, point of view?
Not that I'm aware of, and in my review of the statute, and Travis, please weigh in if I'm incorrect here, but my interpretation of the statute doesn't really speak to an advisory board or committee. It's, you can have an LMD without one. So it doesn't really speak to that. And then getting back to your question about what the community voted on, the community voted on the petition itself. So we went through a process in which the board evaluated the petition that came in, found it to be in the public interest, and then that's what was referenced out as information for the community to consider when they were filling out their ballot. So it was the petition that was community-driven and affirmed by the board that became the focus of the ballot.
So I think we just need to really hear from Travis, really succinct answer. Obviously, the board couldn't at this point say, you know what, we're gonna just change all the dollar amounts that were proposed. Or we're gonna say, we're not gonna let you charge any upland properties. We don't like that piece of it. We can't do that because that's not what they voted on. But it sounds like this, what kind of structure the steering committee would have is not one of those core issues that like akin to changing the rates or who gets charged. It's something lower that we have purview over changing without doing what Commissioner Edwards said, affecting the integrity of the proposal that was voted upon. Is that correct?
Yeah, and Commissioner, in the vein of being succinct as possible, I think you stated it well there. The question on whether or not the management district is being managed or implemented is separate than the question that's before you right now. And quite frankly, I don't know if it's even a live question because if I understand correctly, the current administrative rules haven't been changed. So maybe a question for another day, but it's not before the board in their upcoming action.
You mentioned earlier, Travis, that there was a way that a group that wanted to change the process, there's a way to approach that. I mean, if there's a group that is within the Offut Lake group, I guess, membership, if they feel they got a bum deal or it wasn't fair or whatever, they could do through a petition to dissolve this, if they wanted to do that. Is that possible, that there's a mechanism in place? And maybe that is where this misinformation, if you could call it misinformation, that was put out by the county, if it ends up to be misinformation, maybe it won't end up to be misinformation because they will have an elected representative from Offut Lake representing them. Has that been determined yet?
No, it hasn't been determined.
So we're talking about a maybe?
Yeah, because we haven't passed it.
We haven't passed that yet, so this might be a way to, go ahead, I'm thinking out loud, I'm sorry.
Right.
I'm trying to get ahead of if there's an issue coming up.
I guess that what I'm curious about, Travis, is it accurate to say that at this point where we're at in the formation of the Lake Management District, the Board of County Commissioners, as long as the rates and charges are accurate in accordance with what has been adopted so far, the Board of County Commissioners is at this point obligated to accept the role and move that along. They don't have an option at this point to say no to the Lake Management District. Is that correct?
Yes, That is a pretty good statement. I mean, again, looking at the process, and I think you've all been through it a number of times now, but once it's created and that decision is final, I think it was adopted sometime in July under ordinance 16291. The board is not, through this process, able to reconsider the creation questions, right? So that's off the board. That decision was final. And yes, there's unfortunately, or fortunately, depending who you are, you know, there's really no discretion for the board to really evaluate
Commissioners.
beyond the nuts and bolts.
Right, and then my
Is
next
that-
question is, in terms of dissolution of the Lake Management District, the community could bring forward a petition for any reason whatsoever. It wouldn't necessarily be misinformation by the department or didn't hear about a hearing. They could propose to dissolve it for whatever reason. If the petition to dissolve had enough signatures and were brought to the board in accordance with the law, is that correct?
So you got it. It's RCW 3661-310, and I'll just for the just for folks to hear it out loud, it provides under subsection 1, a lake or beach management district may be dissolved either by the county legislative authority upon a finding that the purpose of the district has been accomplished, which I don't think is at issue here, or a vote of the property owners within the district, right? And so that would be, I think, we're referring to a petition under the dissolution section would provide an opportunity for the property owners to petition, and that requires a certain number of signatures and an actual vote by the property owners. So that process, it can be invoked through that subsection 1 of the statute I just read. But again, from what I can tell, I don't think, the petition's been received or the votes have been casted for dissolution. I will also mention that, and it doesn't have, it doesn't have I think your general notion that, hey, there could be a variety of reasons why members of the public or entities may want to dissolve their entity, and that they're free to provide that rationale to the board and to themselves when they cast a vote, if they were to pursue the dissolution process.
Thank you.
How many signatures are required?
I'm reading, if proposed by, let's see, through a filing of a sufficient petition signed, I'm reading this verbatim, signed by the owners of at least 20% of the acreage within the district.
Again, that's acreage, right? So that's not a simple parcel by parcel number.
Same kind of thing that took place when it was formed,
Right.
right? Yeah, in the reverse.
So my question is in regards, because one of the reasons I voted for this to move forward after the votes came in, and even though it was, and I think I made this when I voted for, it was because it was like I had no other choice because of the RCW, because it's not by the simple majority vote, but it's a weighted vote. But just reading at the comments that were submitted by a citizen, and I'm asking clarification from you, Travis, right? On RCW 3661-100, it says creation of a district, submittal of questions to landowners, majority vote required. So it's the majority vote. I mean, it doesn't really say anything about weighted vote. It seems by majority vote, it can just be as simple. Is there a specific language that says that it has to be weighted? And that's what we have to basically move forward with? And
Yeah,
this is kind of taking a step back on kind of why we're here. I mean, and
Where's the legal authority for the weighted voting process, I guess is the question.
Yeah, no, and I did, see this comment this morning. And I have to I have to caveat and this may be more for the public than the board, but, recognize that lawyers in my office represent the county and its departments, and we have an obligation. In fact, we have a duty to provide those legal services. We don't provide services to the general public or to individuals and entities. So in that vein, it would be inappropriate for me to respond point to point on these legal arguments, especially on a decision that happened in the past, right? So, I that's just a caveat. I don't want to have any impression out there that I'm providing legal advice to individuals. They, if they need legal advice, they'll have to seek advice elsewhere. But with all that said, the weighted voting process, that's all defined under 090. And so the way I at least understand it is 090 says that you get a weighted vote based on the acreage, I believe the acreage or some sort of metric of your property. And then the department takes all those votes that are, you get a certain number of votes depending on the type of property you're on. And then the department takes all those votes and they count them up, and whatever the simple majority is on all those votes, it ends up being the decision, right? So the weighted aspect of 090 pertains to how many votes an individual has, right? It doesn't say one vote has, it gives you the number of votes, and then the number of votes is a simple majority. That's the statutory scheme. And I should add too that the county is really bound to what the legislature passed. And if a citizen wants to lobby or change the law, there is a mechanism, but the county doesn't really have any ability to deviate from that process.
And Travis, if I may, just for a point of clarification, it's not necessarily based on acreage, right? While the proposed assessments are somewhat have a correlation to the size or the proximity to the lake, the weighting is so that the property owner has one vote for each dollar of estimated special assessment or rate and charge proposed to be imposed upon his or her property.
Yeah, thank you for that clarification. It says, again, I'll read it verbatim just to be accurate. It says each owner shall mark his or her ballot for or against the creation of the proposed lake or beach management district, with the ballot weighted so that the property owner has one vote for each dollar of estimated special assessment or rate and charge proposed. So yes, no, thank you. It is, I apologize. It's a little bit nuanced there, but again, that's how the statute handles the number of votes an individual gets. But I think the broader issue here is that the board's already voted and looked at the ballots, looked at the votes. Department presented that during the hearing, and a decision was made. And for better or worse, that aspect of the Lake Management District is final.
And we're now at the next step, right?
Right.
So
You got it. We're implementing the assessment piece of it to ensure that it's accurate. That's where we are at this juncture.
and this other issue is, okay, maybe there'll be new rules, maybe not. We haven't decided amongst ourselves yet.
Maybe a question for the future or
Yeah,
another
that's
day.
a maybe
Yeah.
that we don't know about yet. So, more to come, I guess, on what we decide to do with those administrative rules, I guess.
Right.
And we may take this issue into consideration when we make that decision, I suppose, because there is a mechanism in place. If some folks feel that it didn't go the way they wanted to, they can make appeal through that process. But we're kind of set to go ahead with what we've got, I guess, is the way I see it.
Can we go to the roll of rates? And this one is from the president of the Bronson County Beach Club. And so he had submitted a couple of concerns with some of the roll-in rates. He said property number 20 on the proposed Offut Lake boundary map shows this as one of the parcels to be taxed at $70 annually. And then he says, please note this parcel is owned by the Bronson County Beach Club. However, this is a 12-foot wide parcel that has no water rights to the Bronson Country Beach Club water as shown on the Thurston County Geodata map, nor is it part of our HOA or considered a ratepayer as noted in RCW. And so I'm wondering, and he lists a couple of other properties there, and I'm wondering if those were corrected, what has happened with the ones that because he submitted this on November 1st, 2022.
Yeah, all of those parcels were evaluated, and some of these were discussed prior to the public hearing, months prior to this, because that question came up. Water rights has no implication on lake management districts or parcels that should be charged.
Water rights or water access?
Water rights. He quotes water rights, and then he goes on to talk about water access. So, the parcel in question is a public space owned by the combined property owners out there. Per statute, as I interpreted it, it was subject to charges the same as any other parcel. And this would be consistent with other LMDs that are managed by the county.
So this citizen that wrote this in thinks it was a mistake on the rates and charges. That's what he feels. Is that right?
Yeah.
Because it's not, it's owned by a collective, or what's the argument?
It is, in the packet, it's the, item number 1. And I think it's, I can read it, but, it's here on the information sheet.
Has no water rights
Number
to.
one,
It's on the information.
not on this one.
Nor is it part of our HOA or considered a ratepayer.
Okay.
It has no Offut Lake access whatsoever for whoever owns the property. Drilling a well, what is, yeah, that doesn't even.
Yeah, water rights are a well, or, those considerations aren't part of the requirement for the property to be considered.
And so I think he kind of lists property 69 as well as the other one. So he's saying that basically the BC HOA would be charged twice, one for property 20 and another time for property 69.
Those parcels were a part of the proposed LMD district, correct? To be encompassed as a part
Supported
of
by
it?
the community, yes. So it would be our job to rule them out if
If they're included though, then it's like,
they
I don't, I'm missing this argument, like if they're included, then they get votes based on the weighted assessment of their value, and they get charged based on the mapping, right? I mean, there's no argument that, well, I got charged over here, so I shouldn't get charged over here, like, it's based on the land.
Yeah, it's based on the land, and I guess the same argument could be made if, in this case, the state refrained from the vote, but the same argument could be made for a state-owned property that's supported by tax revenues, and, so I guess the same argument could be made there, but there was nothing in statute that we could find to rule that out.
I guess what I'm trying to figure out, is this a rates and charges issue that we're obligated to deal with, I guess that's,
Well, yeah, I think this falls right within, right? There's someone who's,
I mean, but was this brought to our attention within the right time frame and stuff? So if we don't accept this concern by this party, then have we made a misstep in the process? I guess that's what I'm wondering.
this was submitted on November 1st, 2022.
Yeah, so I mean, it's been there a long time, the concern that was not addressed, is that it?
And when was the vote again?
I know when the ordinance was established, July 18th. I would have to look back to see the date of the vote.
I mean, it's the timing thing, right? There, in terms of the process, you have the proposed geography for the LMD, and you're looking at the parcels, and then you're kind of refining what's in or out prior to it going forward to a vote. And you're trying to eliminate at that point in time some of the potential discrepancies of where there is or isn't access or benefit from the property owners. In this case, when you have an HOA, I mean, it's difficult to sort of slice, well, this parcel has benefit and this one doesn't, when it's still under common ownership. And therefore, if the construct is such that the assessments are appropriated based on size, et cetera, then there's two different charges. It's just the nature of ownership within that LMD boundary.
But I guess if it was, what I'm trying to do here is, I'm trying to do, Travis's work, I guess, which I don't know very much about, makes it real hard to do. I don't wanna have the county be in a situation where we go ahead and move forward and disregard a complaint that this step in today, the step we're dealing with today in the process disregards this. So if we disregard a legitimate complaint brought to our attention, does that void the whole thing, or what's the remedy to that kind of a situation? If we made a misstep somewhere along the line and didn't address it, I mean, we certainly don't want to be in court over this whole thing, and we've got a community that's pretty well split in half. So I could see that could develop, I guess. So I'm just wondering, is this one of the steps that's being brought to our attention that falls within the purview of this decision today about rates and charges? I probably am not articulating that very well, but I'm concerned that something might come of it is all. And Travis, you usually would have this discussion with us in an executive session more than likely, I suppose.
Yes, Commissioner, and the risk of not having all the background, I think the short answer is that all comments that were received during the notice and comment period for this step do need to be considered. So to the extent anything's received during that notice and comment period, that including any objections to the proposed role of assessments, should be considered by the board. And I can't speak to whether or not this comment, I haven't read this comment. I'm not even sure, it's unclear to me whether that was even submitted as a comment to this particular step either. But I guess the short answer is, yeah, if the board received it during that notice and comment period for the proposed rate and charges, you'll need to consider it and then make a decision. To the extent that you need assistance in further deliberating and looking at specific comments, then that would be appropriate, potentially in an executive session if it is a question of legal liability, questions about whether or not certain options come with legal risk and other concerns related to your upcoming decision.
And I think it was considered.
It was considered, I mean, it came in October. It was just a reiteration of the same objections prior to it going to a vote. of the community, so substantially, it didn't change, right? They're just reiterating, they did not necessarily wish to be included in this to begin with, but the vote occurred. So it's less about the assessment and more about just inclusion.
It's about drawing the map. I mean, that sounds like they would have either not done this or if they would have drawn a different map, excluding certain parcels and stuff, but that's not the question. That's not the question for some kind of legal error in terms of inclusion.
Petitioners drive the map.
Petitioners draw the map and that's, you know, and I didn't draw the map. I had no part in drawing the map.
And at this point in time, the fees and assessments have been applied across the board, and there's no error in the way they were applied, which is really the subject before the board.
And we asked questions, or I know I did, and I think all of us did, of staff. Was the map drawn in some sort of, you know, there's always little nitpicky decisions to make, but generally speaking, did they take an approach that was out of the box, completely different than all the other LMDs, inconsistent with state law, inconsistent with other counties? And I think Tim's answered that both Pattison and Offut took an approach to drawing their map that was pretty much within the bounds of what the other LMDs have done, and
Yeah,
there wasn't anything particularly weird. I mean, there's always questions about, you know, upland and how much, you know, to include and whatnot. And I actually went and did a field visit at Pattison to see if that one objected to neighborhood, like, did they have access down that path? And I wanted to get a feel for what their access truly was. So I walked that up and down and around, and, you know, I mean, there was no right answer. It was just a judgment call.
It could be argued that the process itself, as outlined by statute, it has issues, these types of issues, which the board has talked about in the past, but in terms of, you know, are they consistent with other LMDs and how other communities have approached this, and did they do anything outside of the lines per statute? No.
Yeah, but I agree with Commissioner Edwards, and I mean, I know that our decision today is very narrow, but to the extent that there's something that's coming or that we, you know, this is an Offut Lakes work session, let's hear about it. Even if it doesn't change what we're gonna do today, you know, but Travis, I thank you for that statute that pretty much knocks down questions 1 and 2 from the citizen. Very clearly explains that. State agencies being able to vote, I don't know the answer to something like that. I mean, if they're the property owner, I would imagine they'd get to vote. I don't know how they decide, I don't know how Fish and Wildlife decides internally how they cast their vote, and it sounds like they maybe didn't even cast a vote here. But I can't imagine there's a legal problem with that. Unless Travis tells me I'm wrong. The ability of a state agency that owns property to cast votes in this type of weighted, you know, property owner tax levy situation.
Yeah, I'm, as you're talking, Commissioner, I was looking at the statute to see, I recall there is a provision that makes clear that all these provisions, including, you know, voting and assessment, apply equally to private and public lands. Tim, you may have a better sense of where it is in statute, but that was my recollection, that the statute does apply equally, private and public entities.
I believe that's 3661.010, if I'm not mistaken.
And then we've got an answer to we've discussed this issue about the committee. So the only thing left on this list is this last question of how we're doing notice to the residents. There's a sort of a kind of an argument that we're using a partial email list. I don't know exactly all the things that we do to let people know about things. Can you address that, Tim?
Yeah, process-wise, so we, when we receive the petition, prior to submitting it to the board, staff will go through, make sure that the spreadsheet aligns with the boundaries of the map and that every parcel is included within that map, and do our diligence there. That was done early on in the
The
process.
spreadsheet of the property owners and address and.
And parcels and rates, yes. So that is done early on. That is the mailing list that we use for all of our public hearings. There's been 2 public hearings in this process, for, mailing of our ballots. So, that is the mailing list that is used, each
Is this
time
snail
it is
mail, not,
complete.
or email?
So the statute for both public hearings, let's see,
And
at
could,
least,
could I interrupt just for a second? You said there was 2 public hearings so
Yes.
far. This alleges that there were apparently 3. Did we say there was 3 at our last meeting or
no, I
something?
think it says, the comment says that they became aware that there were 3 or may have been 3.
At the last hearing, that there were apparently 3.
Yeah,
And I'm curious, was there 3 or 2? I don't know if it's relevant or not.
yeah, there were 2 public hearings. The board held a public hearing on November 1st of 2022. That was regarding the petition of formation itself. And then they held a hearing on August 22nd, and that was regarding the roll of rates and charges. So I don't know if the information received is being confused with a briefing or some other board,
Okay.
but two briefings in this process.
Public hearings.
2 hearings.
2 hearings, I'm sorry.
Lots of briefings.
Yes, lots of briefings.
So we even get confused what's a hearing and a briefing, so that can happen, I guess, so, yeah.
Absolutely, yeah.
My question before it was interrupted was about
sorry.
snail mail or email in terms of you say we used a mailing list.
The statute is clear for public hearings related to the LMD process, that in addition to our normal advertisement of the public hearing, that we do direct mailings to the property owners. So that mail list that was established early on in the process was used to direct mail public hearing notices and ballots to the affected property owners.
Snail mail,
Snail mail.
yeah, really.
My official
Paper.
term.
We're not
With
trying to
stamps
disparage
in
the
the-
United States
yeah.
Postal Service.
So I was notified of 2, and I attended both. Probably that's all we had, then, is what you're saying.
had 2.
We just had the 2,
We
right?
had 2.
Okay.
Okay, any additional questions?
No, I think, are we gonna make a decision at this meeting or
On Tuesday.
on Tuesday? We're
to
gonna make
vote.
that decision.
Yes.
Yeah.
It's on your agenda for Tuesday.
Okay.
But it looks like, again, we don't really have a choice in the matter.
No material discrepancies in the roles.
So, yeah, I mean, if, anyone watching, right, wants to do a petition to dissolve per RCW 3661-110, they have to collect 20% of the acreage within the district. Those signatures,
Just to clarify, 61 310.
oh, 310.
310 would be the process for dissolution.
Is the process for dissolution of an LMD, and we've done it, gone through the process for dissolution of a special district. Is it the same? We have to make a finding of in the public interest and et cetera, et cetera.
I'm gonna defer to Travis on that one.
Yeah, unfortunately, it is an entirely different statute and dissolution process, Commissioner. So it's, quite frankly, I haven't seen the board go through an LMD dissolution yet. So,
We have to look at that.
if we got to the nuts and bolts, I think the first step is whether there's a valid petition, and we can go from there.
All righty.
I do believe we've had LMDs that have expired in the past, though, and that's a different process. And then somewhere along the line, they had to re-up and go through the whole process again.
Well, certain people were arguing that they're, like, the weeds that were the problem are no longer there. So I guess somebody could try to argue that the purpose of the district has been accomplished because Mother Nature, extinguished the weeds or whatever. I don't know if that's a good argument, because no one really accomplished anything. I don't know if a natural process would qualify. That would be a question we would chew on later with Travis, I guess.
Well, yeah,
Someone tried to make that argument.
if it's through a petition method, they don't need to necessarily achieve that the purpose has been achieved, right? That would have to be under dissolution if the county legislative authority upon finding that the purpose of the district have been accomplished.
That would be us finding that?
Correct.
Their
Um,
petition,
Right,
Then they
which,
would not
to
need a
Travis's
petition,
point,
so.
was you can't really make that finding yet because nothing's occurred. So,
but their petition could be based on something different.
On anything.
Petition
and
doesn't
anything
have
that's
a
just,
base.
there doesn't need to be just
They
dissolution.
could just
I
say,
don't
we don't
want
want
a
to
In
do
the
it.
special district case, it did need a basis. We had to make a finding that it was in the public interest.
Let's have Travis respond.
Yes.
Travis, we'll have you respond to Commissioner Menzer's question.
Yeah, Commissioner, Assistant Manager Geller, it does state it correctly. There's two different processes where it could be initiated. One is the board, one is through petition. If the board were to do it on its own volition through as a legislative body, then they would need to make a finding that it's necessary, or they have to make a finding that the purpose of the district have been accomplished. If there's a petition, there could be a variety of rationale, and then in terms of what would be a valid, let's say the petition was received, they got the requisite votes, and the property owners voted to dissolve it. And I'm reading this as we go. So I think the key distinction here between special districts and the dissolution process for LMDs is that when someone petitions for dissolution for a special district, they're petitioning the board to make a decision. And what's sort of unique here is this statute in this instance allows for the board to make what I would call a sua sponte decision to dissolve on a specific basis, or the members of the LMD can dissolve themselves through a vote. And what's a little different here is that you don't have that public interest evaluation when that vote is accomplished through the members of the LMD to essentially dissolve themselves. So it's a little more unique that, and it goes even a little further here. It really puts the dissolution in the hands of the LMD members themselves. So it's essentially the LMD saying, hey, we don't want this anymore, right? And then the statute sort of says how they can accomplish that. But it does require a vote of their own membership in order to advance that and for it to be a valid dissolution. So I apologize. I may not have all of this. Again, I haven't seen the board go through an LMD dissolution, but my general perspective is that it's unique in that you don't have that affirmative finding that you normally have in a special use district when a petition's received. It's really more of the members voting to dissolve themselves.
So Travis, I'm just trying to think of the mechanisms here. The board would receive a petition to dissolve, then Public Works the county would send out ballots so that there could be a vote, and then count the votes, and a simple majority, either to dissolve or not dissolve, would determine the fate of the district.
Yeah, yes, Assistant Manager, I'm reading the statute as you're speaking, but that appears to be the case. Yeah.
There you go.
Okay,
But again, it's still weighted.
Yeah, it follows
Right,
the
if the
same
votes are
process
weighted
that
in
way.
the same way they were to form the district. Right, same process of figuring out, you get X many, one vote for every dollar of assessment you pay.
okay, it is 12:02. We are adjourned.